Generally, an unconscionable contract, that is, a contract that's oppressive or unreasonably favorable to one party, is unenforceable. In determining unconscionability, a court conducts a two-pronged analysis. First, a court considers whether the contract terms are procedurally unconscionable. And second, a court considers whether the contract terms are substantively unconscionable. In Gatton v. T-Mobile USA, the California Court of Appeal considered whether the contract's arbitration clause was both procedurally and substantively unconscionable. T-Mobile USA is a national cell phone service provider. All individuals using T-Mobile, including Bruce Gatton, were required to sign service agreements. The agreements were typically 1 or 2 years in length. Further, subscribers who terminated their cell service before their agreements expired were subject to an early termination fee of about $200. By signing T-Mobile's service agreement, individuals accepted T-Mobile's terms and conditions. In fact, the agreement stated that if an individual didn't wish to accept T-Mobile's terms and conditions, the individual shouldn't use T-Mobile's service or the phone provided. Also in the agreement was a mandatory arbitration clause that provided that all disputes between individuals and T-Mobile were subject to binding arbitration. Under the clause, individuals agreed to waive their rights to bring class action suits or class arbitrations against T-Mobile. Subsequently, Gatton and others brought a class action against T-Mobile in state superior court, alleging unfair business practices. Specifically, they argued that the early termination fees were unlawful under California's unfair competition law and unconscionable under the Consumer Legal Remedies Act. In response, T-Mobile moved to compel arbitration. The court denied the motion. The court concluded that the arbitration clause, though there wasn't a strong indication of procedural unconscionability, was substantively unconscionable because it prohibited class actions, which was against public policy. T-Mobile appealed to the California Court of Appeal.